everyone, I'm Leonard French, your favorite copyright attorney, and today I thought I'd bring to you a special holiday treat. Your favorite sovereign citizen, Edward Thomas Kennedy, has had his lawsuit against the Law School Admissions Council dismissed. You might remember this free man of the land filed a lawsuit against pretty much everyone involved with his failed application to law school. You'll see in a moment what he did to deserve that. I always find it funny that sovereign citizens will try to use the law to their advantage, usually with hilarious results, while denying that the law applies to them in almost any way. Well, without further ado, I present to you the dismissal of Edward Thomas Kennedy and his response. This is in the United States District Court for the District of Delaware, and this is, of course, Edward Thomas Kennedy versus Law School Admissions Council. He is, of course, from Briningsville, Pennsylvania, which isn't very far away from me. Plaintiff Edward Thomas Kennedy proceeds pro se and has been granted leave to proceed in forma pauperis, or in the form of a pauper or poor person. In other words, no fees in his case. This action was commenced on August 24th, 2018. Plaintiff invokes the jurisdiction of this court by reason of diversity of citizenship of the parties. The court proceeds to review and screen the complaint pursuant to 28 U.S.C. 1915. Actually, I want to see what that is. Notwithstanding any filing fee or any portion thereof that may have been paid, the court shall dismiss the case at any time if the court determines that the action or appeal fails to state a claim, is frivolous or malicious, or seeks monetary relief from someone who is immune. So this is a standard by which the court can get rid of an in forma pauperis case if it is frivolous, even if they're supposed to give a little bit of leeway. Let's let the judge explain that, though. Plaintiff, one of the people of Pennsylvania with an address in Pennsylvania, refused to take the law school admissions test, which is administered by the defendant, Law School Admissions Council. The LSAC, a Delaware corporation, is headquartered in Newtown, Pennsylvania. Plaintiffs alleged that the LSAC refused to forward his law school applications to numerous law schools. In addition to the LSAC, the complaint names defendants the Commonwealth of Pennsylvania, the Pennsylvania Bar Association, Duke University, American Bar Association, and the Harvard Board of Overseers. Those last three are not located in Pennsylvania, but the Commonwealth of Pennsylvania and the Pennsylvania Bar Association are also located in Pennsylvania. Now, if you're in law school, or if you're pre-law, or if you're just interested in this law, or if you follow this channel, you might know that diversity of citizenship is a jurisdictional requirement that allows a court to hear a case. Plaintiff is trying to show or say which federal court should be the court that hears that case. And here, the jurisdiction is alleged as diversity jurisdiction, which means the plaintiff and all defendants are from separate states. You may start to see the problem here. The complaint contains 9 counts, each attempting to raise a tort claim, all but one of which are clearly state law claims, such as trespass, intentional infliction of emotional distress, negligence, etc. Plaintiff seeks compensatory and punitive damages, as well as declaratory and injunctive relief. More particularly, plaintiff seeks admission, tuition-free, with first-class, direct and indirect expenses, to law schools for fall 2018 and fall 2019, as well as an order for several states to grant him the authority to practice law in their jurisdictions. The court perceives no basis for diversity jurisdiction. The complaint does not claim jurisdiction on the basis of a federal question, although the 6th cause of action is restraint of trade, and words used are monopoly and the Sherman Antitrust Act. For the purposes of determining the existence of diversity jurisdiction, the citizenship of the parties is to be determined with reference to the facts as they exist at the time of filing. For diversity jurisdiction, the matter in controversy must exceed $75,000 exclusive of interests and costs. The suit must be between citizens of different states. That's 28 U.S.C. 1332A1. That's you'll see that statute in just about every federal complaint that uses diversity of citizenship. The complaint does not explicitly allege any citizenship of any party. Fairly read, it appears the plaintiff and the LSAC are both citizens of Pennsylvania, as plaintiff is a resident of Pennsylvania and Pennsylvania appears to be the LSAC's principal place of business. In addition, two other defendants are domiciled in Pennsylvania, the Commonwealth of Pennsylvania and the Pennsylvania Bar Association. The matter is not alleged to be between citizens of different states, and it appears, in fact, that it is not between citizens of different states, and therefore the requirements of diversity jurisdiction have not been pled. Despite the reference to the Sherman Act, the complaint does not state a claim for a Sherman Act violation, and therefore the Sherman Act cannot be the basis for jurisdiction. The only facts alleged are that plaintiff did not take the LSAT, and that the LSAC did not forward plaintiff's law school applications to more than his 20 law schools that I guess he requested. The allegation falls woefully short of alleging a plausible basis for an antitrust claim. There being no federal claim, there is also no basis for supplemental jurisdiction over the state law claims. What that means is you can get a state court claim into federal court if you start with proper diversity or whatever jurisdiction in federal court, and then you can also allege state law claims in a supplemental fashion. So, count 1, Sherman Antitrust Act, and then count 2, intentional infliction of emotional distress. And the federal court could adjudicate the state law on the intentional infliction of emotional distress, so long as the primary count there was also sound. If it's not, then you've got a jurisdiction issue, as you see here. Therefore, the court will dismiss the complaint for failure to state a federal claim and for lack of jurisdiction over the non-federal claims. Given the stated factual basis for the lawsuit, there is no basis to believe that plaintiff can amend his lawsuit to state a federal claim. Thus, permitting leave to amend would be futile, and appropriate order will be entered. So, you would think that maybe that would be the end of it, that such a simple dismissal would tell Mr. Kennedy that he does not have the proper basis in law for filing something in this court. Alas, no. This is his response in the District of Delaware, same case, and this is now filed December 6th, which is about a week or so after the judge dismissed the case. And he starts with, notice, in memory of John Fitzgerald Kennedy and Thomas Patrick Kennedy, who both risked their lives in a small U.S. Navy boat in the middle of the Pacific Ocean during World War II, so that we the people and their bloodline and oldest son respectively would be free in the Republic and not subjected to judicial tyranny. Plaintiff Kennedy sees their spirits smiling. The country is a republic and not subjected to either universal charter of the judge or Obama judges. And he has a couple footnotes here, so let's cover these. The first footnote is the universal charter of the judge. I don't exactly know what this is, so maybe we can take a look at that. According to Wikipedia, the International Association of Judges is a professional, non-political international organization of national associations of judges, was founded in Salzburg, 1953, headquarters in Rome. It has as its objects to promote the rule of law and the independence of the judiciary. Its members consist of national associations or representative groups from approximately 87 countries. It is the oldest and most prestigious international organization of judges. It is focused on judicial independence as a guarantee of human rights. Okay, that's interesting that he's citing that. And then he also, in his motion here, says that Obama judges is a phrase credited to Donald Trump. All right, back to our response. This is Edward Thomas Kennedy writing to the judge that just dismissed his case. The Supreme Court of the United States said that recusal is required when, objectively speaking, the probability of actual bias on the part of a judge or decision maker is too high to be constitutionally tolerable. Kennedy hereby now reasonably questions said judge's impartiality and respectfully wishes him to recuse from this case due to the long-term, ongoing birther controversy on the public record, public among and concerning Barack Obama, Michelle Obama, and President Donald J. Trump. For it is probable Kennedy is injured by the assigned judge in loss of rights, for the assigned judge was appointed by Barack Obama. And then he he has a memorandum section here where he says, in a court of record, the said judge is suspended. And then he cites his own law of the case. So here is his Exhibit 1, the law of the case. Again, same court, same case. And he tries to make all these statements. We went over this in the last video, but I gotta cover some of this again. Judicial immunity is a myth. Statutes and codes shall be the rules of decision as long as they are not in conflict with common law. Discretion is reserved to the independent tribunal. Codes are nothing more than a collection of statutes. The California 1879 Constitution defines all California courts to be courts of record. Commonwealth of Pennsylvania maintains confusion and deception with multiple versions of its constitution, etc., etc. This goes on. But let me get back to our original motion for recusal. Plaintiff requests that the judge assigned to this case in this court of record grants plaintiff motion for recusal for cause and recuse! Exclamation point. Signed, Edward Thomas Kennedy, and I'll block out his address, phone number, and such. So that's super interesting and kind of super dumb. What do you think of that? I think our free man of the land might just be a little nuts. I'm not sure how one could expect to avail oneself of the law while simultaneously making every seemingly conscious effort to misinterpret and misunderstand and misstate the law. It doesn't appear that Mr. Thomas Kennedy's efforts to learn the law are actually having any effect on his learning, on his knowledge, and his ability to articulate himself. And I wish I could say that this was the end of it, but it's probably not, because I recently did a search to find other cases by Mr. Edward Thomas Kennedy, and it appears that he is a serial pro se litigant. He has filed about 44 cases in federal district court that I could find, and that's not counting anything that he files in state court around the country or something. So I think I have a little bit more research to do, and then we'll be able to talk about what else he's filed. Well, one of the things that he did file, and one of the things that recently got another one of these really kind of interesting or funny rulings, is this one here in the United States Court of Federal Claims. Now, this is a cool opportunity to understand another court in the American court system. The Court of Federal Claims is not like other district courts. I will, though, let the judge explain. This is Chief Judge Sweeney. In this case, plaintiff Edward Thomas Kennedy, proceeding pro se, appears to allege that various federal and state actors kept him in constructive financial imprisonment after a state judge in Texas declined to vacate a judgment against him. Mr. Kennedy seeks $30 million in damages from each of several individuals and entities identified in his complaint, plus attorney's fees, costs, interest, and declaratory and injunctive relief. Mr. Kennedy also filed an application to proceed in forma pauperis. As explained below, the court lacks jurisdiction to consider his claims. Thus, without awaiting a response from defendant, the court grants Mr. Kennedy's application to proceed in forma pauperis and dismisses his complaint. On November 10th, 2003, Mr. Kennedy filed a document titled Petition in the Nature of a Petition to Vacate a Void Judgment and Collateral Attack Oklahoma State Statute Title 12, Sections 1031-1038, in the Tarrant County, Texas State District Court. Okay, so a collateral attack is like an attack on a case. It's basically filing a second lawsuit to deal with the problems of an earlier lawsuit, but it's not an appeal. You're not appealing the earlier lawsuit. You're filing a lawsuit alleging some kind of wrongdoing in the previous lawsuit. But he's doing that in Texas against Oklahoma. This guy really doesn't understand concepts of sovereignty, does he? The gravamen of Mr. Kennedy's allegations is that Daniel Blumberg, a Texas attorney, allegedly committed felony fraud in connection with a prior federal court proceeding in the United States District Court for the Western District of Oklahoma, the nature and results of which are not provided, in an effort to deprive Mr. Kennedy of money, property, and rights in contravention of various Oklahoma statutes. Though not entirely clear, Mr. Blumberg apparently had obtained a judgment against Mr. Kennedy following proceedings in the Western District of Oklahoma. In his November 10, 2003 petition, Mr. Kennedy alleged that Mr. Blumberg was guilty of fraud because he, quote, knew that the sum of demanded of Mr. Kennedy was different from and greater than a sum Mr. Kennedy could owe under any lawful theory. According to Mr. Kennedy, the purported fraud meant that the Tarrant County judgment was void and insufficient on its face, and therefore the Tarrant County Court lacked jurisdiction to enter a judgment against him. In light of this allegation, Mr. Kennedy asked the court to vacate its earlier judgment and award him $25,000 as the standard damages for fraud, plus costs. What is this standard damages thing? He's used this before. Mr. Kennedy served his petition on Mr. Blumberg as well as Kurt Ellison and Pete Bagley, both of whom were attorneys working at Mr. Blumberg's firm at the time. Mr. Kennedy avers in his complaint before this court that the presiding judicial officer, Judge Bonnie Sutterth, ignored his request. That same month, Mr. Kennedy filed a Civil Rights Act claim in the United States District Court for the Eastern District of California against Mr. Blumberg, Mr. Bagley, and Mr. Ellison, and a Robert Kennard. Mr. Kennedy voluntarily dismissed the case March 10, 2004. As of October 2017, he intended to begin law school in fall 2018 and expressed a desire to become an attorney. Mr. Kennedy acknowledged that filing lawsuits was a way to, quote, test his skills as a litigator. Mr. Kennedy has filed, since 2017 alone, at least 21 federal lawsuits in Pennsylvania, New York, and elsewhere, 4 of which he has voluntarily dismissed. On June 12, 2018, Mr. Kennedy filed the instant suit, which shares similarities with the case discussed above. He names several defendants in his complaint: Mr. Blumberg, Blumberg & Associates, Mr. Bagley, his firm, Judge Sutterth, the State Bar of Texas, the State of Texas, Mr. Kennard, Nelson & Kennard, that law firm, and the State Bar of California, Patelco Credit Union, Stephen Turner Mnuchin, the Secretary of the Treasury, the Department of the Treasury, the Reserve Bank of New York, Thomas Marshall, General Counsel to the United States Postal Service, Megan Brennan, Postmaster General, and the U.S. Postal Service and the U.S. federal government. He contends that each defendant is an agent of the other, and each has his place in the chain of responsibility, and thus all defendants are vicariously liable for each instance of injury. At bottom, Mr. Kennedy alleges that the identified defendants directly, through an agent or in concert with one another, have kept him in, quote, constructive financial imprisonment. Mr. Kennedy refers to the identified defendants as kidnappers and bandits, apparently in connection with his description of financial imprisonment as a loss of liberty, and his allegations that the identified defendants have refused to return stolen property. Mr. Kennedy vaguely alludes to personal property and trade secrets, but does not otherwise identify the property or trade secrets he alleges have been stolen, beyond stating that money is generally owed to him. In his complaint, he alleges that Mr. Blumberg lied under oath in documents and records provided to him in connection with the Tarrant County case in 2003, that Judge Sutterth ignored his petition to vacate a void judgment. By doing so, Blumberg and Sutterth proceeded under color of law and stole funds from Kennedy by denying him funds that he asserts were rightfully his, and resulting in a loss of financial liberty. Since, according to Mr. Kennedy, the Tarrant County Court lacked jurisdiction to enter a void judgment, Mr. Blumberg and Judge Sutterth breached their duty to provide jurisdiction when objection to jurisdiction is asserted. Now, here's something interesting. We have a concept in law that really limits all of this. We have something called proximate cause. There are 2 kinds of cause in tort law: the actual cause, or the but-for cause, what we would call a factual cause, and then there has to be the legal cause. There has to be a legally recognized connection between the actual cause and the claimed injury. So Mr. Kennedy is saying here that someone put him in financial imprisonment constructively by denying him funds that he says he has a right to. Well, forgetting whether or not he actually has a right to the funds, let's pretend that he has a right to the funds and someone's denying him that right. What is the remedy for not getting your money? It's not some kind of extra thing, constructive financial imprisonment, loss of liberty, millions of dollars. No, you get interest on your damages. And if you can prove that it was maliciously done, maybe you get a trebling of damages or some punitive damages or something. But what he's saying here is that they've put him in constructive financial imprisonment by not giving him his money, when really he should just be simply asking for a judgment and interest, and then he takes that judgment to the appropriate county clerk and enters that judgment against a party at the county level, and then has the sheriff execute that judgment against the property of the defendant or the person that judgment is against. And then the sheriff goes out and starts to either take or prepare to take their property, or at least give them a date by which they have to pay up if they want their property to remain. So he's done none of those things, which means he hasn't followed the law, or at least none of this says that he's done any of that, which means I don't think he's followed the law. And this is just nuts. There's no connection between these things and the things that he's asserting. He's speaking very conclusorily, meaning he's speaking as if what he's saying is already determined, instead of explaining it in a way that the judge can make a determination for themselves. So you might say, that guy was negligent and he owes me money. That doesn't tell us that you were in a car crash and he was driving drunk and the cop even said, like, this guy is at fault, you should sue him. Like, you don't present the conclusions to the judge. You don't present the end of the mathematics equation to your mathematics professor. You present the proof. You must give the legal proof. You must show every step of how you got from the alleged injury to your remedy, to your desired remedy, and how the law supports that. And he's not done any of that. He continues. The identified defendants breached their duty to Mr. Kennedy to proceed without injury, secure in his capacities to exercise his right to liberty. The identified defendants, those who are attorneys, have breached their oaths of offices. Mr. Blumberg, Bagley, Kennard, and Patelco Credit Union stole his personal property and trade secrets. Of course, he doesn't give us the fact of what personal property or what trade secret. And Mr. Kennedy has the right to demand and redeem lawful money from the credit union and the Federal Reserve Bank of New York, because he only recently became aware that he could do so. Thus, Patelco Credit Union has been unlawfully using his interest on his money since 1985, when he deposited his first paycheck. Mr. Kennedy demands from each identified defendant, 1, the greater of $1,000 for each day of unlawful behavior, or $5 million for general damages. 2, the greater of $5,000 for each failure to act, or $25 million for damages for the injury caused by defendant's absence of required actions. He also demands the return of the value of all bonds created in these matters in this case, permanent injunctions enjoining the identified defendants from interfering in any way with his lawful rights, and ordering the identified defendants to provide him with a lawful government and honor their fiduciary duty to him. I don't think opponents have a fiduciary duty to you. Quite the opposite. And declaratory judgments that defendants have acted contrary to constitutional right, power, or privilege, and in excess of statutory jurisdiction and authority, and short of statutory right. Well, the judge is going to go into some of these legal standards here, and I'm going to skim some of this. So normally a pro se or unrepresented party, their pleadings are held to a less strict or stringent standard than formal pleadings. They are to be liberally construed. The leniency afforded to a pro se litigant is more formalistic and does not relieve the burden to actually plead proper facts, in this case, jurisdictional requirements. The fact that a plaintiff acted pro se in the drafting of his complaint may explain its ambiguities, but it does not excuse its failures if such there be. In other words, a pro se plaintiff is not excused from his burden of proving by preponderance of the evidence that a court possesses jurisdiction. Whether the court possesses subject matter jurisdiction is a threshold matter, meaning it is something the court must handle right away. Without jurisdiction, the court cannot proceed. In determining whether subject matter jurisdiction exists, the court must accept as true all undisputed facts asserted in the plaintiff's complaint and draw all reasonable inferences in favor of the plaintiff. We're not making a judgment at this time on the facts of the case. The judge is simply saying, if in a hypothetical world what you've alleged could be true, then yeah, you can survive a motion to dismiss, or you can have jurisdiction or whatever. So the judge goes into the Tucker Act, and this is really important because remember, we're talking about sovereigns here. You're talking about a person claiming to be more or less a sovereign citizen, or someone to which the law doesn't seem to apply, against a sovereign nation. Well, what does the word sovereign mean? Without actually looking up its exact definition, it basically means that the United States is its own entity and that it is not answering anyone's call of a claim or injury or anything like that. It is the most powerful entity in the region. Now, is the United States sovereign against China? No. And then that's why you get world politics, because now China and America have to negotiate and behave as more or less equal sovereigns on a not so equal playing field. But the point is that the reason the United States is sovereign is because of its power. It's really not like it can't do whatever it pleases. And what are you going to do about it? That really is where the buck stops. The United States is sovereign, and so if it says you can't sue it, you really can't. It literally has the force of military might. It has the organization of the entire federal government. There's really nothing that you're doing. So in the legal history or legal foundation sense, we consider nations to be sovereign. In this case, the United States as a sovereign is immune from suit unless it consents to be sued. The waiver of this immunity may not be inferred, but must be expressed, and unequivocally, meaning it must not be ambiguous. It must be a clear statement. Further, when waiver legislation, or a law that waives sovereign immunity and allows the government to be sued, contains a statute of limitations, those limitations do apply, and they provide a condition on the waiver of sovereign immunity. The Tucker Act, the principal governing statute governing the jurisdiction of this court, the principal statute governing the jurisdiction of this court waives sovereign immunity for claims against the United States, not sounding in tort, that are founded upon the United States Constitution, a federal statute or regulation, or an express or implied contract with the United States. The Tucker Act is merely a jurisdictional statute, does not create a claim. Instead, the substantive right must appear in another source of law, such as a money-mandating constitutional provision, a statute or regulation that has been violated, or an express or implied contract with the United States. Besides meeting the Tucker Act requirements, any action in the Court of Federal Claims must be filed within 6 years. So there's both a statute of limitations and a jurisdictional limit here. And so the judge says, under a liberal construction of Mr. Kennedy's complaint, he is alleging claims for these things: embezzlement, perjury, fraud, conspiracy, harassment, breach of fiduciary duty, negligence, and various rights violations under federal, state, and private individuals and entities. Mr. Kennedy also appears to collaterally attack decisions issued by the courts in Oklahoma and Texas. Again, that means that he's suing here over a judgment in another court. Normally you would appeal. This is not an appeal. This is not an appeal to the appeals court in those regions. This is an appeal to a different court. So it's not an appeal, it's a collateral attack. Without inquiring into whether Mr. Kennedy's claims are barred by claim and or issue preclusion, which would be like if you had adjudicated your claim before, you can't adjudicate it again. This sounds like double jeopardy, but we don't call it that when it's not criminal. It is clear that the Court of Federal Claims lacks jurisdiction over his claims. Consequently, Mr. Kennedy's complaint must be dismissed. So the judge goes into what the Court of Federal Claims is. It's only meant for those claims that were listed before. The United States itself is the only proper defendant in the Court of Federal Claims. This court lacks jurisdiction over any claims alleged against states or localities or government entities from the state or officials or employees. Similarly, they lack jurisdiction over private parties and individuals. In other words, if the relief sought in the Court of Federal Claims is against other than the United States, the suit as to them must be ignored as beyond the jurisdiction of the court. To the extent that Mr. Kennedy complains of improper conduct by parties other than the United States federal government, this court lacks jurisdiction over those claims and they must be dismissed. To the extent that he does assert civil rights violations and such, those claims are outside of the reach of the Tucker Act jurisdiction of the court. First, the Court of Federal Claims is not a district court. Second, the federal district courts possess jurisdiction to entertain claims alleging civil rights violations. Third, this court lacks jurisdiction to entertain claims sounding in tort. In short, the court must dismiss civil rights claims or torts asserted by Mr. Kennedy. The court lacks jurisdiction over criminal matters. He alleges criminal activity has occurred. However, it is well established that the Court of Federal Claims has no jurisdiction to adjudicate any claims whatsoever under the Federal Criminal Code, etc. Such claims must be dismissed. The Court of Federal Claims lacks jurisdiction over Mr. Kennedy's statutory claim. He asserts that he's entitled to demand and redeem lawful money from Patelco Credit Union and the Federal Reserve Bank, and he cites 12 U.S.C. 411, which is the statute that says that cash can be used to pay government debts, it can be deposited in banks, or it can be redeemed for lawful money at the Treasury Department or any Federal Reserve Bank. The purpose of this statute is to make clear that the Federal Reserve notes, cash, are the authorized currency of the United States. To the extent that this statute imposes a duty on the federal government, the Treasury Department and Federal Reserve Banks must redeem cash for lawful money when cash is presented for redemption. However, Mr. Kennedy asserts that he may demand lawful money at any time, without presenting cash equal in value to the amount of lawful money demanded. This is basically saying you can exchange money, dollars for dollars. Why would you do this? Well, let's imagine you have some old beat up dollars. You could exchange some old ones for some new ones. Or let's say that you want to change denominations of bills or something. You can do that. And that's what that law says. Such an allegation is frivolous on its face. As such, the allegation fails to invoke the jurisdiction of this court. And then he goes into the collateral attack issue. In addition to alleging claims involving civil rights, criminal matters, and statutory violation, he appears to collaterally attack unspecified decisions of the U.S. District Court for Oklahoma and Tarrant County, Texas. However, the Tucker Act provides no such jurisdiction to entertain collateral attacks on decisions of other courts. Mr. Kennedy's claims are also time barred. In other words, he's filed them too late, being that he's filing this in 2017 and the claims were from 2003. The Court of Federal Claims lacks authority to grant equitable relief or injunctions. It is well settled that the Federal Court of Claims lacks the authority to grant such equitable relief. They cite several cases and then dismiss that claim. And the court declines to transfer the case, saying that it's only appropriate to transfer when the court lacks subject matter jurisdiction. Correct, we have that here. The case would have been filed in the court receiving the transfer, or could have been. The case could have been filed in the court receiving the transfer. Okay, so that's possible. And 3, the transfer is in the interests of justice. Well, which do you think the court went with? Transferring Mr. Kennedy's case to an appropriate district court will not serve the interests of justice. In Khalil v. United States, another judge of this court declined to transfer the case because doing so would serve no purpose since the plaintiff's claims had already been considered by a district court. In the instant case, Mr. Kennedy has similarly already availed himself of the opportunity to present his claims against the federal government to a district court. In other words, the courts that would have jurisdiction have already considered plaintiff's claims. Therefore, as in Khalil, transferring Mr. Kennedy's claims would be futile. In any event, transferring a case where the plaintiff wants to test his skills as a litigator does not advance the interests of justice. Accordingly, the court declines to transfer any part of plaintiff's case to another court. They do allow him to proceed in forma pauperis, but that's futile because, of course, it gets dismissed. The Court of Federal Claims lacks jurisdiction over claims involving civil rights, torts, or criminal matters to entertain frivolous claims or collateral attacks on the decisions of other courts and, with exceptions not relevant here, award equitable relief. Therefore, the court has no jurisdiction to consider any aspect of Mr. Kennedy's complaint. Further, transferring Mr. Kennedy's case to a district court is not in the interests of justice. Accordingly, Mr. Kennedy's complaint is dismissed without prejudice for lack of subject matter jurisdiction. Mr. Kennedy's application to proceed in form of pauperis is granted. No costs. The clerk is directed to enter judgment accordingly. It is so ordered. Margaret M. Sweeney, Chief Judge, the U.S. Court of Federal Claims. So that's super interesting, and I thought you might find that quite entertaining. So I don't know what to tell you. This guy doesn't seem to be learning his lesson. Certainly doesn't seem to be learning anything about being a federal litigator from the 44 lawsuits. I find it interesting because I didn't have to file 44 lawsuits to learn how to be a federal litigator. I just studied. So I don't know. Maybe Mr. Kennedy should back off a little bit and realize that he's never going to be a lawyer while behaving like this, and he's either going to have to shape up or face the music. And that's our show for today. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney. This is a community-supported channel. You can support us on patreon.com/ljfrench. Thank you very much to our supporters at the $500 level for the month of December, Justin Rogers. Thank you very much, Justin. Really appreciate your support. At the $50 level, Jonathan Doe, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Andy, Verement, Tayne, William Gonzalez, Michael Pearce, Terry Crisp, Richard Fournier, aka Breakfast Demon, Spirit Bear, Negrey, JAXMerrick, and Daniel Perez. And I will have the rest of you scrolling on the crawl as I don't have an LED panel with me today. So thank you for joining me. Meanwhile, I'm having a great time here in Glasgow, Scotland, spending the holidays with Miss Kay. And the people here are very nice, and everything here is very nice, aside from being a little wetter than I'm used to. But I happen to enjoy public transportation, and very, very nice here. So I'm looking forward to spending the rest of the holiday here. We're gonna be making more videos for you using this kind of setup, and taking more videos with the Osmo Pocket. So I'll present all this to you as the holiday goes. Look forward to it. Spending some time with Miss Kay and spending some time with you guys. Love you all. I'm Leonard French, your favorite copyright attorney. Have a great holiday.